Alrighty. Hi, everyone joining us. We're going to give everyone a few minutes to kind of come in. And it looks like I can promote Tammy to panelist.
I just did it.
I'm here.
Woohoo, we did it.
Welcome.
Okay. All right. So have we let anybody join yet?
Yes,
so
we have 10 people.
Okay,
We
good.
started the webinar.
That's
So I
great.
think-
Okay, welcome everyone. We had some technical difficulties thank you for waiting and being so patient. And I think we'll get started once I get the okay that we have enough people in.
I think we're good to
We're
go.
good? We're
Yep.
good? Okay, great. Welcome everyone to our summer education and employment training series. We are excited to offer 6 free webinars. They are designed to empower families, students, and professionals with tools and information to support success in school and beyond. So throughout this series, we will cover important topics, including the manifestation determination review process and school discipline, which we will be presenting today, IEP basics, advocacy, and back to school tips, Social Security and benefits for transition age youth, your rights under the Americans with Disabilities Act, understanding CAP, and dispute resolution options in special education. So again, our goal is to provide practical strategies and resources that you can begin to use right away. Before we begin, I would like to introduce myself. My name is Tammy Sebastian, and I am a special education advocate with Disability Rights Ohio. I use she, her pronouns. I am a white woman in my 50s with shoulder length blonde hair that I have pulled up in a bun today. I'm also wearing glasses, and I'm also joining you all from my home office. To support accessibility, today's session includes closed captioning. It should be at the bottom, I'd say not center, but right side of your screen. And the session will be recorded, and we will be posting that on the website afterward. You're welcome to place your questions in the chat box or in the Q&A. Those are also at the bottom of the screen. The chat box is on your left and your Q&A is on the right. I will be monitoring them throughout the training, and we will also reserve some time at the end of the training to address your questions. So today's session will run approximately 45 minutes. And again, it's being recorded. So now it's my pleasure to introduce you to today's presenter, Emily Durrell, who will begin to guide us through today's topic. So Emily, it's all yours.
Thank you so much, Tammy. I'm so happy to be here. So my name is Emily Durrell. I'm a special education attorney here at Disability Rights Ohio. And I'm going to go ahead and pull up my presentation, which is here. And someone's going to need to tell me, can you see it, please?
You can see it.
Okay, wonderful. So today we're going to be talking about protecting against school removal, obviously with a focus on students with disabilities. Just as an introduction, like I said, I'm an education attorney at Disability Rights Ohio. I'm a white woman in my 30s with long brownish hair, and I'm also in my home office, which is blurred out right now. You can't really see the curtain rods I have leaning against the wall. Some information on DRO for those who don't know. We're a nonprofit corporation with the mission to advocate for an equitable Ohio for people with disabilities. I put our website here. We have tons of resources in all subject areas if you're interested in checking that out. And if you ever need assistance, you can call us at that number, or on our website, you can access our web intake form if you don't like calling people like me. So today we're going to talk about school removal, like I said. So here's kind of our roadmap, the outline of what we'll be talking about. We're first going to talk about the types of school removals. There's four main ones. There's three real ones and one kind of fake one. So we're talking about emergency removals, suspensions, expulsions, and informal removals. Then we're going to talk about the protections available to students with disabilities, the MDR process and other protections. And then we're going to talk about preventing improper removals, kind of methods you can use to make sure your students' rights are being protected. I'm open to questions during the course of the presentation, and Tammy's probably going to help me answer those if she sees stuff in the chat. So if you have a question about a slide as it comes up, feel free to enter it. You can also ask to speak. I think that's an option if you don't feel comfortable like typing in the chat. I am just going to remind everyone that this is being recorded. Please do not disclose any private information. We also can't answer any questions that would be considered legal advice. So we can answer broad, vague, general questions, but nothing super specific. If you do have a specific question, you might want to reach out to our intake line and see if you can get assistance from someone. And here's another note before we get started. So we're going to talk about school removal laws and their related protections as applicable to public schools and to community or charter schools. Private schools have very different laws. That's to say they don't have a lot of laws and protections regarding school removal. So we're not even going to touch on that today. Just a heads up, if you have a student in private school and you're looking for advice, this is probably not the presentation for you. All right, so let's jump into the types of school removals. First school removal I wanted to talk about is the emergency removal, and this is a removal for less than 24 hours that behavior that poses an immediate danger to any persons or property or is disruptive to the educational process. And then a little extra note here, students third grade or under can only be removed for the remainder of the school day. So that's less than that 24 hours. So the purpose of an emergency removal is if there is an unsafe situation, the school is able to send that student home. If there's like an immediate danger or the student's being disruptive to the educational process, you can see these types of removals maybe being improperly applied, and we'll talk about that later. The next type of removal we're going to talk about are suspensions. So a suspension is a removal from school for 10 days or fewer. There are two types of suspensions, which I don't really go into in detail, but there are in-school suspensions and out-of-school suspensions. If a student is in school, but they're not in their class, it could be considered like a larger school removal. Once again, we're going to talk about this a little later, but just I wanted to give you guys that clear delineation now. Before a student is suspended, they have to be given a written notice of the reasons of the suspension, including the date, time, and location of the incident. That notice also has to give the student information on their right to an informal hearing, where the student has the opportunity to challenge the allegations and or explain their actions. Unfortunately, this is how parents feel. Unfortunately for parents, the school can hold that informal hearing without the parents present. So typically what that looks like is that's when the student is called into the principal's office and the principal says, can you tell me what happened? Walk me through it. This is what I heard. That's technically the informal hearing of the suspension. If that informal hearing would result in the student being suspended, then the parent must be notified in writing of the suspension and they would have a right to appeal the suspension. They have to receive that notification within one school day. And the amount of time a parent has to appeal that suspension varies school district to school district. Once again, if you have any questions, feel free to pop them in the chat. Tammy, are you saying anything?
There is nothing there right now, Emily.
Okay, let me know if that changes.
I will, definitely.
Here's kind of a breakdown of the suspension timeline, which I think is helpful. So we have like the violation, then the student is given that written notice, then the student has that informal hearing, which is sometimes just, sitting down in the principal's office. Then the school gives the written notice to the parent. Then the student and parent can request an appeal. Then after that appeal, the school would give written notice of its decision to the student and to the parent. The other type of school removal, which is more serious, is expulsion. So the typical period of expulsion is 10 to 80 days, with 80 being like the max. However, there are some exceptions to that maximum for really dangerous behavior. So there is the possibility of a 1-year expulsion if a student brings a weapon to school, like a firearm or a knife capable of causing seriously bodily injury. If the student commits an act that's a criminal offense when committed by an adult and results in serious physical harm to persons or property, or if a student makes a bomb threat. A student can be expelled for 1 year if the student possesses a knife or a gun. I don't know why it only says knife. Commits an act that is a criminal offense when committed by an adult or makes a bomb threat. Oh, this is the same thing. Permanent exclusion may happen if the student is over 16 and convicted of certain criminal acts. So if the student is convicted of bringing a gun to school, that student could potentially be permanently excluded from school after that. There is, however, a new type of expulsion. This is a new law that was passed this year that allows school districts to develop an expulsion policy that would allow them to expel a student for 180 days for actions that pose imminent and severe endangerment to the health of other pupils and school employees. The student will have to satisfy certain conditions, including a report by a psychologist or a psychiatrist on their relative threat level before the student can return to school. And then at the end of that 180-day period, if the student has not shown sufficient rehabilitation, the expulsion can be renewed for an additional 90 days. And this process can repeat indefinitely until the student graduates. So I only have, well, I guess I have 2 slides on this. If you want more information though, we have written a blog post on this type of expulsion. There's a lot of details there with like having to get a psychologist report. Who chooses the psychologist? Can the parent choose a psychologist? A lot of concerns there. So if you're interested, I highly recommend you read this blog post. We have the QR code here too. And I'll come back to this slide. I did want to go over what is considered imminent and severe endangerment for purpose of this type of expulsion because it's a little different than the other things that can lead to expulsion. So bringing a firearm or knife capable of causing seriously bodily injury to school or a school event, committing an act that is a criminal offense when committed by an adult, making a bomb threat, these are things that would tie into like that 1-year suspension. However, they added on this additional thing that could be considered imminent and severe endangerment, which is making an articulated or verbalized threat, including a hit list, threatening manifesto, or social media post that would lead a reasonable person to conclude that the pupil poses a serious threat. So if you work with kids like I do, that might be a little concerning because sometimes students say things they don't really mean about, oh, I'm going to shoot up the school. Oh, I'm going to, tell Tommy what's coming to him, stuff like that. The way the law is written, that could be considered imminent severe endangerment, which could lead to this longer and potentially permanent expulsion. One pro, I shouldn't say pro, one silver lining to this type of expulsion is the school district has to make the decision to adopt this type of expulsion. So it's like a vote that the school board has to have whether or not they want to have this type of expulsion. So your school district might not have it. Once again, I highly encourage reading more about this if you're interested. There's the QR code and it's on our education blog on our website. I'll give you 1 second to fill that out. All right, expulsion rights. So students, much like with the suspension, students are entitled to a hearing before that expulsion is imposed, and then they get written notice of the intention to expel, which is going to include the reason for the expulsion, notification of opportunity to appear, time to appear, and whether that permanent exclusion is being sought. So typically what a school will do is usually they'll suspend a student first, and then they'll say in the suspension paper, like also we intend to expel. So then that hearing would happen during the period of the suspension or right after this period of suspension. If the expulsion is granted, the school has to notify the parents and the school board within a school day. The notice also should include the right to appeal, so you can appeal this decision. And then if the expulsion is for more than 20 days, parents have to be given notice on services or programs that the student can use to work on improving behavior. If the student is expelled for more days than remain in the school day, they also have to be presented an opportunity to work off the expulsion through community service over the summer, which is interesting. And here's a little breakdown of the expulsion timeline. So we have the violation occurs. Like I said earlier, typically that student is suspended first, and then the suspension due process rights would apply. School sends written notice to the student and parent informing them of their intent to expel the student. And then the school has to hold a hearing within 3 to 5 school days. The school then sends written notice to the parents informing them of its decision. Then the student can request an appeal. And then after that appeal, the school once again would have to provide written notice to the parents about its decision. All right, we're coming up on our last type of removal, which is not a real type of removal. It's an informal removal. And this is the most problematic removal and a type of removal that I see quite often. An informal removal is basically when a school removes a student from school without following proper disciplinary procedures. So I gave an example here because this is how it often looks like. School calls you and says, you need to come and pick up your kid right now. Gotta come and pick him up. That's kind of all they say. You go and pick your student up. As these removals are informal, they're typically not tracked. So very rarely will you see like an attendance sheet saying the student was informally removed. You might see the student had an excused absence. Um, you really want to avoid these type of removals, and we're going to talk about that a little bit later, why it's important to avoid informal removals. Alrighty, we're going to move on to protections for students with disabilities. If you have any questions about those types of removal, please put them in the chat. We'll also have time for discussion at the end of this presentation. All right, so all students with disabilities have civil rights protections, and the very basic civil right protection that we're probably all familiar with is a student cannot be discriminated against on the basis of their disability. So kind of, growing out of that, if a student is removed from school due to having a disability, that would be considered discrimination. And the way that the law has kind of set out, this is how we're deciding whether or not the student is being discriminated against, is the law says the school has to have this meeting, it's called a manifestation determination review, to decide whether or not the student's behavior is due to their disability. So an MDR, a manifestation determination review, is available to any student who's on an IEP or 504 plan. However, a student who is not on either of those plans could be protected by an MDR if the district is deemed to have knowledge that the student was a student with a disability. So the school would be deemed to have knowledge if the parent expressed concern in writing to an administrative staff or to the student's teacher that their student needed special education or related services. Also, if the parent requested an evaluation, like we call them ETRs, if the parent wrote to school and said, I want an ETR done, or if the student's teacher was expressing specific concerns about a pattern of behavior to a supervisor. So if the teacher was going to one of their supervisors and saying like, wow, I've really been struggling with Timmy in class, he's having all these behavior issues, what should I do? That could be the school being deemed to have knowledge that that student has a disability. However, if the district goes ahead and evaluates that student, but finds that they don't meet the qualifications for an IEP, then the district is deemed not to have knowledge that the student has a disability. And this is the same even if the school has like that suspected disability meeting and everyone sits around and says like, we're not even going to evaluate because we're not seeing any concerns in school right now. So if the school does that, they're not deemed to have knowledge and the MDR protections would not apply to that student. Okay. MDR timeline. So school is required to perform a manifestation determination review anytime the school proposes a discipline measure, so like a suspension or expulsion, that's going to result in a change in placement. What is a change in placement? A change in placement is a removal from school for more than 10 consecutive school days or a removal from school for more than 10 days cumulatively for substantially similar behavior, which is something I want you guys all to be very familiar with. So if a student is removed for disruptive behavior Monday, Tuesday, Wednesday, and then he's back to school the next week, but then the week following that, he's removed again for disruptive behavior, and those days are adding up to 10 days, the school should perform a manifestation determination review to make sure that they're not discriminating against this kid by removing him so much for his disruptive behavior. The MDR process. The main question that is being answered in that MDR is, was the conduct the student exhibited, the conduct that potentially could result in suspension or expulsion, does it have a direct and substantial relationship to the student's disability? Or, this is another thing they can look at, was the conduct a direct result of the school's failure to implement the student's IEP? So there's 3 main steps in the MDR process. The first step is everyone's going to review what is the student's disability? They're going to review school records. Parents can bring in private medical information. Parents can also share personal knowledge of the student. Schools might have staff observations. Maybe the teacher can say, like, I've noticed, this happens in class. We want to make sure that we really understand what is the student's disability and what are its symptoms. Then we discuss what is the incident that occurred. What was the conduct that the student exhibited? To do that, you can review school records, staff observations of whatever happened that day. Sometimes the student will be in the meeting and we can interview the student. What were you thinking? What happened that day? One kind of like asterisk I'll put on this is if the student could potentially be expelled, you may not want the student to be in there admitting to certain things. And if there is a potential criminal issue with whatever the student was doing, you definitely don't want the student in there saying like, yeah, I brought a gun to school. So you can always plead the fifth in an expulsion hearing or in an MDR. That's my advice to you. The third part of the MDR process is asking, was the behavior due to the student's disability or due to the school's failure to implement the IEP? Kind of asking those big questions and pulling all this information together. We're pulling together what is the student's disability? We're looking at the incident that occurred and we're asking, does that student's disability have any relation to this incident? How substantial is that relationship? Or was that incident due to the IEP not being performed? The outcome of the MDR is that if the school answers yes, that the student's conduct is a manifestation of their disability, then that school cannot suspend or expel the student for more than 10 school days. The school also has to conduct a functional behavior assessment, which is often called an FBA for short, unless they have already conducted an FBA before. And they have to implement a behavior intervention plan or a BIP addressing that student's conduct, whatever the issue is that's arising in school that could potentially lead to suspension or expulsion. If the student already has a behavior plan, the school also has to review and modify that behavior plan. That being said, if the school's like, we believe in this behavior plan, we're just going through an adjustment period, they wouldn't necessarily have to modify it. They just have to maybe double check and make sure that all the documents are in place, that all the supports are in place that we need, and go from there. If the school answers no, that that student's conduct is not a manifestation, then that student can be disciplined the same as a non-disabled peer. So all the things we went through for, your right to a hearing and appeal and stuff for suspension, expulsion, then the student would go through that process and all those outcomes would apply to the student. There are also special circumstances in the MDR process. So the law knows that there are some situations in school that are just inherently unsafe. And if a student engages in this unsafe behavior, the student can be removed from school, even if the behavior is due to their disability. So the removal is shorter than a full-time expulsion. It's 45 days maximum removal, and the student has to be removed to what's called an interim alternative educational setting, meaning the student still has to be educated even during the period of their removal. Types of special circumstances, these will probably look familiar to you. The student carrying or possessing a weapon at school, the student knowingly possessing or using illegal drugs or selling illegal drugs at school, the student inflicting serious bodily injury upon another person while at school. And then what is an interim alternative educational setting? It varies. It can look like a separate school. It could look like a separate classroom. A lot of times you see home instruction, but the student must continue receiving instruction during the period of that removal. I should also say the interim alternative educational setting should be based on what setting the student can receive a free appropriate public education in. So if your student has no ability to learn from home and they're not going to learn from home, they get easily distracted or something like that, home instruction is not a proper setting for them during the interim alternative educational period. There's also another exception. This is kind of like an exception for everything, not just MDRs. Schools don't have to allow the participation of an individual with a disability if their participation would pose a direct threat to the health and safety of others. And this isn't only about like violence, it can be about contagion, or I've seen situations where like a student is allergic to another student's service dog. That service dog might not be allowed to come into school. And so a direct threat is defined as a significant risk to the health and safety of others that cannot be eliminated by modification of policies, practices, or procedures, or by the provision of auxiliary aids or services. So a student can only be labeled a direct threat in like this very extreme circumstance when there's nothing a school can do to modify their policies or to help the student. And then before the school can decide a student is a direct threat, they have to conduct an individualized assessment on whether or not that student is a direct threat. Oh, I see a link to my blog in there. Next slide. There are some other protections that I wanted to mention. So a student on an IEP must continue to receive a free appropriate public education, even if they are removed from school by way of a suspension or expulsion. So the student has to get their special education services and continue to receive instruction in their curriculum, even if they're expelled. And then the placement where the student receive that instruction has to be appropriate for the student to progress in their curriculum. So kind of similar to what I was talking about with the interim alternative educational setting. If the student can't learn in home instruction, then that's not going to be the appropriate placement for them during the period of the expulsion. In that case, you might be looking at like an alternate school, somewhere where that kid can still make progress in their curriculum. And here's another little protection. This applies to all students, even students without disabilities. All students cannot be suspended or expelled if they are third grade or below for minor and nonviolent offenses. So keep that in mind. Sometimes schools forget about that one, but you won't because you watch this presentation. All right, so now we're going to talk about preventing improper removals. And this is kind of like where you can brainstorm, like, what can I do to make sure this doesn't happen to my child? The big thing I wanted to talk about is don't fall for informal removals. I cannot tell you how many calls I get from parents who say, the school's calling me like every day or once a week asking me to pick up my student. And I go and pick them up, but like nothing's changing and he's missing a lot of school. That's like a huge red flag. If a student is removed informally without that school following proper procedures, it's likely that a lot of their rights are being violated. So first of all, the school, if they're informally removing a student, they're not keeping a record of how often that student is missing school. So for the MDR, we were talking about that 10-day limit. Once the student hits 10 days out of school, those protections apply. The school has to perform a manifestation determination review. If there's no record of whether or not 10 days of school are being missed, the school isn't being, nothing's triggering within the school to say like, oh, we need to look at a manifestation determination. There's also the issue where students are not receiving due process. So like we talked about with suspension, you have the right to a hearing, you have the right to appeal, same thing with expulsion. With an informal removal, you don't have any of these rights. A lot of times schools will kind of pose informal removals as like a positive. So like I'll have schools offer to remove a student for like months. They'll just say, the student can't come back to school. He's not expelled. He just can't come back to school. Saying like that's a positive alternative to us expelling the student because one that looked bad on his record. But if you think about it, you had no way of proving whether or not that student even should have been expelled. You had no way of doing a manifestation determination to look at whether or not that student's behavior was due to their disability. So you gave away a lot of rights there by saying like, yeah, I'll keep my kid home. And that more likely than not, the student could be receiving services during that period of removal. So my tip to
Emily?
everyone is, yes.
There is a question, but it looks like Kristen might be answering it. So it says how do schools operated by a county board of DD fit into these roles if they feel they can no longer serve a student with multiple needs? Is their process different, and does the responsibility go to the school district instead? Sorry, Kristen, if you're currently typing.
Yeah, so the school district that the student lives in is always the responsible party if a student's being placed out at like a county board school. County board schools they're considered providers, so they're providing the education to the student, but the district responsible is still the public school district, unless you've set up some different kind of thing where you're like paying out of pocket to the county board, I guess. I don't know if that happens though. So depending on how you have your agreement with the county board, how the student's being sent there, I guess my answer would change. But generally, county boards do have the ability to say, like, this program is not right for your student. Student cannot return. Public school districts, they have to provide services no matter what. Hopefully that answered your question.
Yeah, and Kristen also just said generally the school district where the parent lives places students in the county board of DD. It's the
Mhm.
school district of residence that has the obligation to follow the procedures and rules.
Yeah,
Okay.
I'm glad we're on
Yep.
the same page, Kristen.
Me too,
Um,
Emily.
all right, so my big tip, like I said, request that every removal be recorded as a formal removal. So if that school is calling you and saying you need to pick Alice up right now, you need to ask the school, okay, well, is this an emergency removal? And see how they answer. They say, yes, this is an emergency removal. We have an immediate danger to persons or property. Let's say, okay, I can come pick her up, but please record this as an emergency removal. Reason being, you can then use that down the line once you have 10 days of removal to say, like, look, we have 10 days of removal, let's do the MDR. If those removals add up to the equivalent of 10 days, request an MDR. So in a perfect world, a school would be the one, beginning the MDR and telling the parent, like, we're going to do a manifestation determination right now. However, sometimes schools, either they aren't tracking those numbers or they don't know about the cumulative days thing. So parents can always request an MDR themselves. If you notice that the student has been out of school for 10 days or more, for more than 10 days, then you can request an MDR. Some benefits of having an MDR is it might cut down on the number of informal removals or even formal removals because the school now sees that there's this 10-day limit. And it can lead to better behavior support in school because if you'll recall, if a behavior is determined to be a manifestation or yeah, a manifestation of their disability, then the school has to put together an FBA and develop a behavior plan. So if you're looking for behavior supports, that could be a good place to get started. I also wanted to give some information advice on preparing for an MDR because I think this is also confusing for a lot of families. So the biggest thing, maybe even before the conduct even happens, is you want to make sure that the school knows what your student's disability is. So a lot of times I'll see parents who will have diagnosed disabilities, like their student has a diagnosis of ADHD, but they've never shared that with the school. And if the school doesn't know that the student has special needs, then the school isn't going to be implementing any supports for the student. And the school has no obligation to perform an MDR. So I really encourage parents, if you have a student with a disability, to let your school know and try and get the student supports if that's what they need. Like if they need a 504 plan, try and get that with the school. If they need an IEP, try and request one from the school. But if the behavior has already happened, this is the situation we're in, I would immediately make sure that the school has all the current information on the student's disability. So if the student has any private medical assessments that the school doesn't know about, if the student has any recent diagnoses that the school doesn't know about, any updates on treatment, I would just let the school know where things stand with that student's disability. Another big thing to do is to bring in a medical professional who is working with your student. So if the student has a pediatrician that has diagnosed them with ADHD, or the student has a counselor, the student has a behavior therapist, get them involved in this MDR process. Some really kind therapists and practitioners that will actually come to the MDR and then explain the connection between the behavior and the student's disability at the meeting. But due to scheduling, we can't always make that happen. At the very least, I would advise that parents get a letter from a medical provider explaining this is so and so's disability, this is Alice's disability. These are the symptoms of her disability. This is what I see in my treatment of her. This is what we're seeing at home. This really does highly relate or is due to or causes her conduct in school. Another way you should be preparing is you need to review your students' records and come into that meeting prepared to point out the information in their records that show the conduct is related to their disability. So if a student is impulsively, they're potentially going to be expelled for impulsively throwing their pencil at someone in class. I've seen this happen. You want to review their records and see, does this student have impulsivity? Like, is this related to their disability? If the student has ADHD and they're highly impulsive, you have a really strong argument that, like, yes, this impulsive behavior of throwing a pencil is related to their diagnosed disability of ADHD. Also, don't forget that portion of the MDR that's looking at whether or not the IEP was performed. So you want to make sure that the IEP was being performed. If the student has certain supports in their IEP, that those were being performed the day of the incident. And then if you have the feeling that the IEP was maybe not being performed, know which part of the IEP wasn't being performed. Was he not receiving a certain service or support? Was he not getting, he's supposed to get breaks, he wasn't getting breaks. Those are pretty clear-cut examples of the school not performing an IEP in a way that would help that student manage their behavior and not escalate to a point where the student has to be suspended for it. That's kind of my advice for MDRs. My last piece of advice is to seek help when you need it. So students have the right to be represented by an attorney in an expulsion or suspension, due process hearing or appeal. They also have the right to be represented by an attorney during an MDR. DRO, our organization, can help provide additional information or even assistance. And I wanted to put two really helpful resources in here. These are resources that I personally find helpful. The first is Parent Center Hub. This is kind of like parent-centered information and guidance. Their guide on the manifestation determination review process is what taught me about manifestation determination reviews. So I disseminate it to like everyone if I can. DRO also has a really thorough self-advocacy resource center. And this QR code, this just links to the Special Education Resource Center. But like I mentioned earlier, we provide assistance in a bunch of different areas. If you're interested in education, though, check out that QR code. We have tons of resources. We have sample letters you can use, really good information there. I'll give everyone a moment if you want to scan those QR codes. And if you have any questions, please put them in the chat.
And there are none currently, Emily.
You guys are not a very talkative bunch. I need more questions. All right. So our kind of final thing we're going to do today as part of this presentation is we're going to walk through a real life example. These are not real names and all these facts I haven't fallen into my lap just like this, but this is, similar to something I see quite often. So I kind of want us all to walk through this together and think about what can we do, what's happening in the situation, and what are the next steps. So let's go through it. So we have Frank. He is in 3rd grade. His mom, Rose, is receiving calls about once a week asking for her to come pick Frank up early from school because he's acting out. Frank just received a diagnosis of ADHD from his pediatrician, but he doesn't have any related supports at school yet. Rose is at risk of losing her job because she has to come to school and pick Frank up so much. What should Rose do? So while we're thinking of this, I have a couple questions for you guys to be thinking about. What kind of school removal is being performed here? Could Frank have any protections under the laws that we've talked about? How can Rose make sure Frank is being protected? And if you want to know anything else about the situation. So feel free to jump in the chat with ideas.
Okay, I'm watching for you.
And we can start simple if you want to say what kind of removal do you think is being performed?
Nothing yet. Oh, okay. Somebody did. So somebody said involuntary.
Involuntary, very close. Informal. This is a pretty classic type of informal removal that you'll see. Notice the school isn't saying Frank is suspended or Frank's expelled. They're not saying we're emergency removing Frank for behavior. They're just calling the parent and saying, just come pick him up. We're tired of dealing with him. He's acting out. Pretty classic example of an informal removal. Patricia
Yeah,
had it.
Patricia did have, yeah. In the Q&A. So I'm going between the chat and the Q&A.
Is there a way I can see the Q&A? Why can't I see it?
I'm not sure, Emily, why you can't see it.
Just not tech savvy enough. Well, I'll rely on you, Tammy, to tell me what's in the Q&A. So what about
That or
protections?
Lindsay? I think Lindsay's helping me too, so.
Yeah, I'm back up to the backup.
Okay.
Oh, wait, I think this is the Q&A.
It should have a
Okay.
little question mark in a box.
I found it. Okay. Next is, could Frank have any protections under the law, do you think, based on this fact pattern? He
Oh,
got a
there's something in the
diagnosis.
Q&A. We have someone said due process.
Due process, potentially.
Okay, so potentially we're looking for something else though, right, Emily?
Yeah.
Not going that far.
So because Frank has this diagnosis of ADHD, and because he's being removed so often, he could be, should we go all the way back to this slide? I'm doing it. Eligibility. He could be eligible for a manifestation determination review on the basis that this school might be deemed to have knowledge if his teacher is expressing specific concerns about a pattern of behavior to a supervisor. My guess is if the student is being referred to the office once a week or twice a week, then there's some conversation that's happening there with the teacher being like, oh, we're having issues again today. In my, opinion, that would be this teacher expressing specific concerns, which could mean that the student could get an MDR if he's removed from school for the equivalent of 10 days, these like informal removals. Another thing that you can look at, because he has, going back to the slide, sorry if this is making anyone sick. Because he has this diagnosis of ADHD, the parent can also make a request that the school sees if he needs any supports in school. And if he's being removed from school this often, it's highly likely that he could benefit from some supports in school related to this ADHD diagnosis. So the parent can request an evaluation from the school to see if he's eligible for an IEP or a Section 504 plan that would add supports and services, to make sure that he's regulated in school and that he's not acting out anymore. When you answer, please post in the Q&A or raise your hand to talk. Our chat is disabled due to being out in a webinar format. Now you know.
I will make sure I say that the next time. That is why I couldn't see anything in the chat. Okay.
Yeah, this is our first training this summer, so we really appreciate everyone joining us as we work out some of these kinks. All right, so those are the potential protections that I see. I would also advise Rose, how can she make sure Frank is protected? I would advise Rose anytime the school is calling her to ask, is he being removed from school? Is he being suspended? Is he being expelled? Is this an emergency removal? And if so, I need you guys to do what you need to do on your end and make a record of that. If he's being suspended, you've got to send me a notice, stuff like that. What else would you like to know about this situation?
And a reminder to put that in the Q&A or raise your hand.
Or raise your hand.
Yeah, I should have caught that earlier. Sorry, friends.
Oh, it's okay.
Anything else you want to know about the situation? This is kind of my catch-all question because sometimes I'll actually have parents point out things that I didn't even notice in these little hypotheticals I put together. I think I'd want to know like what exactly is happening in school. Um, and if you want to get that information from the school, you can ask the school to, gather some behavior data for you. Ideally, the school, if this behavior is so extreme to the point the student's being removed quite often, ideally the school would then go ahead and start that functional behavior assessment, and just start gathering the data on why is this occurring, when is it occurring, and what supports can we put in place to make sure it's not occurring anymore.
That was going to be my question, Emily. Did they do an FBA? Did they do a functional
Mhm.
behavior assessment?
If a child is being taken out of school involuntarily by the school, can that become a truancy issue? Um, Oh, that's a good question. I don't think so because the school is the one removing the student. Um,
Emily, could I add something?
yeah.
Just because I've had that come up for me before. I always tell the parents if they don't have any documentation from the school, it's hard to show that they're not keeping them home. So I don't know if that's what they're asking them as far as truancy is concerned. So if they don't have any documentation with those informal removals, that might be where they were going with that. What does that look like then if there's no documentation?
Yeah. Well, if there's no documentation, then the school wouldn't be tracking the students' attendance, basically. So I couldn't see that becoming a truancy issue, but potentially you can't predict what these schools are going to do sometimes. So I don't want to give a definitive answer, actually.
Right. That was
Any
a great
other,
question, though.
it was a good question. Any other comments on this example here? Any other ideas you have about how to tackle the situation? If
Oh,
I
there's
was,
some more.
oh, there are some more.
Oh, no, it's just the same two that popped up. Sorry.
Okay.
I got excited.
All right. Well, if I was working with Rose, I would tell her, well, first I would explain to her what an informal removal is and why we shouldn't be letting the school get away with it. I tell her about her rights for that manifestation determination potentially to be put in place if he's being removed 10 or more days, just due to the fact that there seems to be a pattern of behavior. And I'm guessing that the teacher is expressing this to their supervisor. I would ask Rose to reach out to the school and request an assessment for special education services like a 504 plan or an IEP. She can also request an FBA or behavior plan to like directly address any behavioral issues that are arising. And hopefully, once she does all that, we're going to see less informal removals from the school. All right. Next slide is just general questions and discussions about school removal. So if you have any thoughts about what we talked about today or any questions, feel free to pop it in the Q&A. Me and my colleagues would be happy to answer them. Any opinion on the weather lately? It's been really hot.
I do not see anything in the Q&A. You probably just did such a great training that there was no questions.
Tired of the rain? Yeah, it's been really rainy. I heard there was like flooding in Lancaster, which kind of shocked me. It's the end of July. Why is there flooding,
Yeah, lots of rain at one time,
Mm-hmm.
not when we
And
need
it's
it.
usually when it rains, the humidity goes down, but that's not happening. It's just raining and it's still humid.
Yeah.
It was a good training. Thank you. Oh, I appreciate that so much, Patricia.
Well, with that being said, Emily, do you have any last thoughts, or I don't think there's anything else in the chat. We can go ahead and wrap it up.
Yeah, I would just remind everyone to know your rights. Be really hyper aware of those informal removals because that's one of the most common issues I'm seeing. If the school is offering you this amazing deal where they say if you keep Jimmy home for the rest of the school year, we don't have to do the expulsion process, be really suspicious of that as well because you might be putting a lot of rights uh, to the side and you might not be getting all the instruction that you should be getting. I hope that the information in this presentation can kind of help you avoid those pitfalls. And hopefully everyone is staying in school this year and getting all the education they need, and you never have to call DRO.
Yes, great. Well, thank you, Emily. That was a great training. And thank you, everyone, for joining us today for this session of our summer education and employment training series. So we hope that you found the information helpful and that you're leaving with some practical tools and insights that you can use moving forward. And like Emily said, and not have to call DRO. Wouldn't that be great for you? If you've had a question that we didn't get to, obviously, I think we got to all of them. You can still reach out, as Emily has said. You can fill out our intake request form, or you could call our intake request phone line. So as a reminder, today's session was being recorded, and we will get that posted to the website soon. And feel free to revisit it if there's something you missed or share it with others. Also, we will hope that you join us for the next session in the series, which will be taking place on August 5th. And I believe we will be back with Emily, if that's right. And Emily is going to be giving us IEP basics, advocacy, and back to school tips. So thank you for sticking around and being patient with us as we worked out some of those kinks. And we hope you will join us back on August 5th or throughout the series. Have a great day,
Yeah.
everyone.
Thank you so much.
Thank you. Take care. Bye-bye.
Bye.